Part 5. The Laws of Land and Sea. Moving the law of the sea onto the land. With the Louisiana Purchase, the Roman Civil Code was established on the land of North America via the Napoleonic Code. One of the keys in the Napoleonic Code is the requirement that a family or surname must be chosen and continued from generation to generation. This provided a continuous family name that could later be codified in the civil system and attached to the public person as a decedent estate. The passage and adoption of the Napoleonic Code in Louisiana, as it coincided with the Louisiana Purchase, began the systematic intrusion or overlay of maritime and admiralty law, inclusive of the containment field of the civitas, to be bound to the public codes of civil procedure that was perfected during the next 163 years. The final stroke of that brush on the canvas overlaying the land was something called the Revised Federal Lien Registration Act in 1966, which was passed after silver was removed from public circulation on January 1, 1965. That act was enacted because Congress, being severely compromised, passed the Federal Tax Lien Act of 1966, by which the entire taxing and monetary system, i.e., essential engine, was placed under the Uniform Commercial Code. The act essentially placed all elements of taxation and monetary issue under the purview of the UCC. Also see the description of Federal Lien Registration Acts by the Uniform Law Commission. Keep in mind that within the context of the essay, A Special Report on the National Emergency of the United States of America, linked above, the author is missing some key and essential elements that were not understood when it was written 12 years ago, which shall be made clear in this discussion. Thus, Roman Civil Code, the Lex Mercatoria, maritime and admiralty jurisdiction, including the key maritime function of insurance, commercial monetization that establishes a debtor-creditor relationship, and the Uniform Commercial Code became the binding law that adhered to those who were subject to public policy under bankruptcy administrative requirements. All of these are controlled by the law of the sea and the management of the civil body. Ultimately, these are all wrapped under the top-dominant, Vatican-controlled UNIDROIT that created a uniform global commercial code and mercantile system of debt-based monetization controlled by statutory civil procedures and uniform acts for the creation of commercial paper, circulating currency, and negotiable instruments, securitized documentary currency. The history of the process of bringing the law of the sea onto the land began in the mid-1800s with key acts and Supreme Court decisions. The first of these is the Limited Liability Act of 1851. It created a limitation of liability for shareholders of maritime vessels or companies to the extent of their investment. This made sense at the time for investors in such operations to be protected with limited liability only to the extent of their investment, so that they did not have general liability. The key for our discussion is to understand that in the next 100 years, this was transposed such that U.S. corporate officers who were effectively acting upon and operating the public commercial vessels of the franchises discussed herein could be protected by their public errors and omissions bonds, as well as U.S. and state public officers would be similarly protected by public bonds of office when administering such public vessels in commerce. This gave them effective limited liability and the ability to hide behind bonds without any personal responsibility as long as they fulfilled public policy. Notice that the full title of the act refers to ship owners, and of course, the owners of the commercial vessels as franchises of the United States is the United States itself. At the same time, the seminal Supreme Court decision in the Propeller Genesee Chief versus Fitzhugh case was a pivotal case that began the movement of the law of the sea onto the land. In that case, the Genesee Chief caused damage to another vessel on Lake Ontario en route to another state. Ultimately, the SCOTUS found that it could bring the law of the sea onto the navigable waters of the several states under the power of Congress to regulate interstate commerce and on other factors. In the decision for the case, the following quote is most important for us to see and understand in this context. This power to confer jurisdiction to federal courts on constitutional grounds is as extensive upon land as upon water. The Constitution makes no distinction in that respect, and if the admiralty jurisdiction in matters of contract and tort, which the courts of the United States may lawfully exercise on the high seas, can be extended to the lakes under the power to regulate commerce, it can, with the same propriety and upon the same construction, be extended to contracts and torts on land when the commerce is between different states. And it may embrace also the vehicles and persons engaged in carrying it on. It would be in the power of Congress to confer admiralty jurisdiction upon its courts over the cars engaged in transporting passengers or merchandise from one state to another, and over the persons engaged in conducting them, and deny to the parties the trial by jury. Now the judicial power in cases of admiralty and maritime jurisdiction have never been supposed to extend to contracts made on land and to be executed on land. But if the power of regulating commerce can be made the foundation of jurisdiction in its courts, and a new and extended admiralty jurisdiction beyond its heretofore known and admitted limits may be created on water under that authority, the same reason would justify the same exercise of power on land. Here, in this one case, we have exactly how the United States established a basis to later apply its admiralty jurisdiction to all cars, persons, merchandise, and vehicles operating in commerce on the land, and on this basis convey the definition of a vessel in commerce unto the person as a franchise of the bankrupt United States under the administrative control of the admiralty jurisdiction of the United States. It also declares that by the application of such jurisdiction, the federal courts have the authority to deny to such persons the right of a trial by jury, because such a right is only conferred upon living men and women on the land free of the constraints of the admiralty jurisdiction thus defined. Following the Civil War, a succession of acts were passed by the military Congress that was in place since the Constitutional Congress ceased to exist upon the disbanding of that body in April 1861. This was when the Southern state senators walked out of Congress and the body was adjourned sine die, without day to reconvene, which means from that point forward, a proper Constitutional Congress has never reconvened since that day. This started with the passage of the federal acts implementing civil rights, the first two creating a holding system for the newly freed slaves to bind them right back into a form of servitude via the 14th Amendment U.S. citizen status for persons born or naturalized into the United States. Prior to this, there were only citizens of the states of the Union who had citizen status of the original United States as private American nationals and not as federalized United States citizens, keeping in mind that the United States is a federal corporation, not the original perpetual union. The civil rights granted by these acts created a form of privilege as a benefit for the citizens of the civitas, or civil body. Additionally, the private American national status is subordinate to the superior status of a private state national, i.e., private Californian, private Nevadan, etc. At the same time, New York passed its omnibus-styled Code of Civil Procedures that was linked to the Napoleonic Code via the Metropolitan New Orleans. Metropolitan being a title of the Archbishop of the New York Archdiocese, under which all other metropolitan municipalities and jurisdictions are subordinate in the same way that all judicial systems worldwide are subordinate to the Roman Curia of the Holy See. Concurrent with the Civil Rights Acts were the passage of the 14th Amendment, the Reconstruction Acts, and the Act of 1871 that incorporated the District of Columbia, and other acts through 1878 that perfected the creation of the United States in corporate structure and character. At the same time, the English Parliament across the waters were busy passing the Judicature Acts that merged law with equity, while across the land on the other coast, California adopted the New York Civil Code en masse, which was entirely against its original Constitution of 1849, and prepared to issue a new Constitution, circa 1879, based on said Civil Code that would allow a newly classified citizen resident of the United States to vote in one of the first steps towards a complete federalization and incorporation of the entire federal system. The civil codes thus passed were linked to the Napoleonic Code as a means to ingress Roman civil law onto the previously lawful standing of the people, which would later culminate in the hybridization of all law forms under the federal rules of civil procedure passed in the 1930s. This was all done to separate the two estates discussed above and convert the people with lawful standing into a new status of U.S. person, U.S. citizen, and a bonded surety of a bankrupt franchise. How is the decedent estate bound by the law merchant and commerce? This is the key question to ask. To answer it, we have to go back to ask, what is an estate? For every living man, woman, and child on the planet, there exists an ancestral lineal estate that each has the capacity to claim. It is ancestral because it is derived from our ancestral family line, and it is lineal because that ancestral line, by definition, is our lineage proceeding through time from the past of our ancestors to our current embodiment in this lifetime. The only thing that we truly carry from one generation to another is our genetic heritage, which holds the resonant memory of our ancestry as it has existed through linear time in this dimensional reality. Thus, our ancestral estate is ultimately the genetic code, our DNA in every cell of our bodies, as well as the unseen lineage through that cellular DNA to our ancestral origins, physically as well as multidimensionally. This entire topic under discussion is presented with specific context to the United States. But keep in mind that all other nations are also bankrupt corporations that bond their citizens through registration and attachment. And all these nations are registered with the SEC in the United States as shown above, and therefore it ultimately applies to almost every human being on the planet. Upon birth, a newborn being is almost immediately processed through a series of steps that turn the baby into a ward of the state and the mother and father into legal guardians rather than lawful parents. As such, the baby is considered a foundling and is considered separated from the underlying ancestral estate and becomes a ward of the state. And a ward is overseen by a warden, which is the superior officer of a prison. The mother registers the baby in the role of informant, the one who places into form, while leaving the father's identity out of the registration process. This effectively cuts off the patrilineal relationship between father and child, severing the way ancestral estates pass from one generation to the next. The child is now registered with the state and is considered a foundling and a ward of the state, with all state actors and officers then effectively becoming wardens. In lieu of the natural father, the state becomes the parens patriae, which by definition vests parental authority into the hands of the state and ultimately vests the role of the father in the Pope, holding presumed authority over all flesh and all souls of the world. This creates a bifurcation in status whereby the state becomes the executor of the underlying estate, and the bureaucracy of the matrix system becomes the extensions to manage and administer the estate, while at the same time the public franchise is established in parallel as the decedent estate to manage the debtor facility for purposes of public policy and the creation of public funds. The record of live birth is converted to a statistical entry into the system of vital records and human resources, and the franchise of the United States is created in order to facilitate the creation of public funds, with the franchise being acted upon as the debtor facility, the entity in which debt is created and by which debt service must be performed. Each documentary instrument in electronic or paper form, from the registration form to create the vital record onward, becomes an expressed trust that creates public funds in the form of monetized debt to circulate as currency on the public side of the ledger. The underwriting guarantor of that commercial paper is the ancestral estate that progressively creates, builds, and accrues value through the course of a lifetime, at the end of which all such public debts, claims, and liabilities are finally settled. This arrangement exactly reflects that of the Sestake V Act of 1666, whereby estates can be passed into the hands of executors when a Sestake V, living beneficiary, is presumed lost at sea and pronounced dead. Upon the death of the surety, the ancestral estate is never claimed and dies intestate without an expressed will. It is then considered abandoned and returns to the state through the legal mechanism of escheat laws. This is how vast amounts of off-book, off-public record, private capital has been built against the bonded debt facilities we operate our lives through in the realm of commerce, by and through which all the evils of the world have been financed, such as black operations, secret space programs, political corruptions, covert intelligence, surveillance, and so much more. In short, this is how we finance our own imprisonment and bondage through the perpetual debt enslavement of our lives. All of this operates and functions through the mechanisms of military occupation, emergency banking, and war powers vested in a centralized system through the Office of the Executive and Administrative Bankruptcy Rules in Admiralty and Maritime Jurisdiction. This is further elaborated upon as we proceed forward in this discussion. In such a system, the occupying force operates under specific rules established by international treaties pertaining to the rules of war on land, treaties of 1899 and 1907, and the nature of military occupation. In these rules, as established via international treaties at the Hague Conventions, the definition of a belligerent, found in Treaty of 1899, is one who takes up arms against an invading force. Later we will see that the use of commercial paper within the federal zone is considered a belligerent act if and when such acts are done contrary to the public policy of the occupying military force. In the 1907 treaty, reference is made to the duties of usufruct, which is a requirement of military occupation to maintain the occupied territory and population within a system of civil order. Translated, this means that the civil population must follow every code, ordinance, rule, and statute, as long as it is considered an enemy combatant under conquest, and if any member thereof takes up arms, commercial paper, against public policy, they can be considered a belligerent and subject to suppression pursuant to Section 4 of the 14th Amendment and later enactments such as the Patriot Act that defines such belligerent acts as paper or domestic terrorism. Military occupation and the duties of usufruct. When a military occupier takes control of a civilian population and territory, something known as the duties of usufruct are activated. Usufruct is defined as the right to the use of the fruit of another's labor or production. This mandatory obligation was established in Article 55 of the 1907 treaty, found in United States statutes at large, which provides that the occupying state shall only be regarded as administrator and usufructuary of the public buildings, real property, forests, and agricultural works belonging to the hostile state and situated in the occupied country. It must protect the capital of these properties and administer it according to the rules of usufruct. But this only applies if and when a member of the civilian population is not acting in a belligerent manner, and the nature and status of a belligerent is established in the 1899 treaty in the second article, where it states that the population of a territory which has not been occupied, who, on the enemy's approach, spontaneously take up arms to resist the invading troops, without having time to organize themselves in accordance with Article 1, shall be regarded as a belligerent, if they respect the laws and customs of war. If they do not respect the laws and customs of war as defined in the 1899 treaty, then they are considered rebels, insurgents, and enemy combatants, and are subject to suppression under the 4th section of the 14th Amendment, via military tribunals set up for such purposes, which is how all courts within the United States operate at this time. This applies to all who remain in the status of bonded surety to the bankrupt franchise, who have been given license to use the property of the United States and to act in commerce. If one corrects their status to be a private man or woman on the land, then the United States is compelled to act under the duties of usufruct as described above. Quote, "The occupying state shall only be regarded as administrator and usufructuary of the public buildings, real property, forests, and agricultural works," end quote, and is compelled to do so under the rules of usufruct. This includes the duty to pay for all fees, taxes, repairs, maintenance, and other requirements for the preservation of the capital assets, which is consistent with the appointment of public officers as trustees. This is important to remember with respect to just what is commerce and why it is considered a field of battle, wherein the very use of commercial paper is considered an act of war and therefore is the equivalent of the taking up of arms to resist the invading force. Thus, it is the removal of our participation in such a field of battle that renders the presumption of enemy combatant and belligerent status null and void, and holds the key to our liberation from this endless state of useless and destructive warring in this world. Be that as it may, when one remains in the status of bonded surety to the bankrupt franchise, created soon after birth for us to operate and function in the world, we are provided a license to do so, to essentially engage in actions otherwise considered illegal, but only to the extent and as far as we abide by the requisite rules of such activities. These rules are the very codes and statutes discussed above as the Law Merchant, Uniform Commercial Code, and all the tens of millions of federal, state, county, municipality, and local codes and rules for the maintenance of the civil body under military occupation, emergency banking, and war powers. This is how the law merchant and all the rest of it becomes binding on living men, women, and children in the United States and the rest of the world. It is essentially under the same military occupation through the third city-state of the Triple Crown, Washington District of Columbia, which was established for two primary purposes. Number one, to be the military arm of the world system, and two, to be the arbiter of uniform commercial codified systems of monetized debt and securities, the use of which is a civil privilege as defined in civil rights acts and many subsequent codified systems. As previously stated, code is the root of the word codicil, with the latter meaning an additional instrument attached to a will that directs the administration of an estate. Thus, we are confined by our lack of will in the world system to be bound to the rules, codes, and regulations as if they are codicils to our own expressed will for the administration of our own estates. All codes are really codicils that the state, as executor or administrator of both estates, chooses to apply to the functional decedent estate in the public, because the estate is administered without a will, so in its role as parens patriae, it can do what is required to administer the estate. Our collective abandoned ancestral estates lie underneath the public system and are there to provide underwriting for the creation of the monetized debt paper we use as public currency. The codicils as codes effectively wrap the commercial franchise through which we are privileged to be able to eat and drink and have the appearance of a free life, but not the true liberty of a free being. In the abandonment of our true sovereign free will, we have abandoned our true estates and have allowed our life force to be subjugated to an overarching global corporate e-state. This is no better illustrated and no more readily seen as in the current technological language wherein everything is electronic and prefaced with the E for electronic, e-commerce, email, e-state, and further showing the subjugation of the true self as only the little ego, little I as in iPhone, iPad, iOS, and so forth, leading inexorably to the merger of self and electronic medium into the tidal force of singularity and transhumanistic fusion with the artificial intelligence control matrix of ever more present godlike proportions.